My name is John Brooks, and I'm talking about exceptionality, and I'm focusing on the legal issues and the rights that the exceptional students have in schools and in education, mostly focused on the disability side, not the gifted and talented side. What is exceptionality? This is the long definition. It gives them a few bullet points. Exceptional children differ from the norm, either below or above the regular student or the normal student, as it says. Exceptional children is an inclusive term that refers to children with learning and or behavior problems, children with physical disabilities or sensory impairments, and children who are intellectually gifted or have special talent. In short, students who have intellectual disabilities, mental retardation, students who have superior ability, or students who have physical disabilities can all be viewed as students that can require individualized or specialized instruction. If they officially need the instruction specialized, then they can officially be exceptional. Litigation. The rights were not easily attained for students. Educators were reluctant to give them the rights because of the risk of trying to educate them, or the risk of maybe harm they could cause because of their mental state, whatever it might be. They were eventually, by law, required to give equal educational opportunities to exceptional students. So that's why they incorporated it into their schools, not because out of the goodness of their heart, but because of the requirement by law after the students have earned their rights and won them through the courts. Brown versus Board of Education. Brown was the court decision found that separate but equal was not equal. This was focused around African American students and racial discrimination and segregation. So it found that separate but not equal was not equal, and set the precedent that schools not be segregated in any way. So segregation generates a feeling of inferiority as to their children's status in the community that may affect their hearts and minds in a way unlikely ever to be undone. That's a quote from one of the judges from this case, the ruling judge, and said that segregation early in life could lead to issues later in life, and they may never overcome them. So parents and guardians thought that them being in school around peers, around people their own age, would be beneficial for them, whether they were learning the same curriculum or not. The educational value was still there. Looking at Park versus the Commonwealth of Pennsylvania. The Park is the Pennsylvania Association of Retarded Children, and they brought a class action suit against the Commonwealth of Pennsylvania. The court ruled in favor of these plaintiffs and stipulated the students should have the education as close as possible to the education that their peers are receiving, whether they're exceptional or not. Basically, the Commonwealth of Pennsylvania was accepting federal funds and not accepting disabled students or mentally challenged students, whatever the case might have been for each individual student. They were accepting federal money, but not following all federal laws by giving them all the equal opportunity. Mills versus the Board was similar to the Park versus Commonwealth. This was just the District of Columbia's version of that. They had 18,000 students not in school for various problems, behavioral, epilepsy, or mental retardation, intellectual disabilities, or physical problems. The district is now to provide due process procedural safeguards. They had to allow these students to come to school and find ways to get them there and provide them with the same rights and opportunities. These two high-profile cases brought suits across many states, resulting in positive findings for the plaintiffs. Legislation. Much of legislation was patterned after the civil rights legislation for ethnic minorities. The United States laws changed the way individuals with disabilities would be treated and served as a model for much of the world. Real quick, looking at Section 504. Someone cannot be left out because they are handicapped or because of their handicap alone. There has to be justification and a reason to be left out. In short, the Public Law of 94142, the Education of All Handicapped Children Act, is 1975, signed into law. Free and appropriate education, procedural safeguards, education in the least restrictive environment, individualized educational programs, parental involvement in educational decisions related to their children, and fair and accurate, non-biased evaluations. Americans with Disabilities Act was signed in 1990 by George Bush and is the most significant civil rights legislation since the Civil Rights Act of 1964. It was designed to end discrimination against individuals with disabilities, whether it be for employment, for transportation. You can't not do something in America because of your disability or because you can't walk. There has to be room for wheelchairs in the bathrooms or in the aisles of the restaurant, whatever it might be. You cannot not allow someone to have a service because of their disability. And then real quick, looking at the IDEA, Individual with Disabilities Education Act. These were amendments to Public Law 94142, and it included the addition of students with autism or traumatic brain injury as a separate class, but also entitled to special services. Transition plan was required as part of the IEP, and new language to emphasize the person before the disability were the amendments in the IDEA. And that's the end of that's a brief overview of most of the laws and litigation legislation that's affected disabilities and exceptional students.